For today's conference, we are going to talk about copyright. So copyright shouldn't prevent you from doing your best academic work, but ignoring copyright until the end of your program can create unnecessary stress. This session will provide an overview of copyright consideration related to preparing a graduate thesis, publishing journal articles, and working as a teacher assistant at the University of Alberta. Now, this conference will be carried out by Amanda Wakaruk. She is MLIS and MES, is the Copyright and Scholarly Communication Librarian at the University of Alberta. Her research interests include an exploration of the impact of copyright injury and shield and separate but related advocated to the reform of crown copyright in Canada. So thank you very much for being here. Yeah, the podium is yours.
Great, thank you. Hi, everyone. Great to be here with you today and online. I see we've got a pretty good group online as well. Yeah, my name is Amanda. I'm the Copyright and Scholarly Communications Librarian here at the University of Alberta. And I just want to start by saying that no one in the Copyright Office or the library, for that matter, can provide legal advice. So this is a session that is educational in nature. And we're going to talk about copyright issues that all graduate students should be aware of, with a focus on practical things to consider when compiling a thesis. That's the focus for today, but I'm open to any kind of questions you want to throw at me related to copyright in the Q&A. Now, before we go any further, we need to be on the same page about what the heck copyright is in the first place. So I'm just gonna, oh, that's weird. There we go. And so I'm going to throw this out to you. Now, there are only two people in the room, so I am going to rely on people online, you know who you are, to type in the chat as well. So this is throwing out to you guys. What do you think copyright is? Ownership over intellectual property. Yeah, that's a big component. Now, copyright is one of 5 intellectual property mechanisms that are available to Canadians in terms of legal rights related to IP. So copyright is one of 5 things that we normally consider being in the range of IP. So that's one aspect of it. Ownership, you bet. What else? Any chat? No. Okay, well, that's a good place to start. I'm not going to force people. Here in Canada, we have something called the Copyright Act, and it establishes rights related to what you see on the screen here. We're looking at a picture of the act in the background. It's a massive piece of legislation. So what I've tried to do is kind of give you the most important points on a slide, which, as you can imagine, is fraught for all sorts of reasons. But for our purposes here today, it'll provide enough of a background. So very quick overview of copyright law in Canada here. The Act gives rights holders the sole right to produce, reproduce, perform, or publish a work. Okay, that right is immediate, time limited, and transferable. What this looks like in practice is that if I write a book, for example, as soon as it is in fixed form, and that can be electronic, paper, doesn't matter format, as soon as my original idea is in fixed form, it is immediately protected by copyright. So only I can share it, can reproduce it, perform it, or publish it. If anyone else does these things with it, that's copyright infringement. So if you shared a piece of my book online, technically, I can file a claim of infringement and you would be breaking the law. Now, that's an extreme interpretation, right? And the legislators understood this, or an extreme approach, I should say, to the sharing of information. And our legislators understood that. So they added what are called exceptions to infringement in the Act to give users like you permission, if you will, under law, to share other people's works, bits of my book, in very specific and limited ways. Okay, so these are called exceptions to infringement. And in particular with academic work, we often talk about fair dealing as an exception to infringement. Now, I said specific ways, but those specific ways aren't articulated in the act itself. Okay, so you could share, let's say, half of my book on the open web and think that's fair. I might disagree with you and ask you to stop doing it and file a claim of infringement, maybe with damages. We would go back and forth and hopefully find a resolution between us. But if we didn't, I could escalate it to the courts. And that's when the courts get involved. And only a court of law can give us a specific determination of what is fair or not under copyright law. So that's sort of the broad strokes of how the copyright regime works in Canada. And I want to throw another question out to you. Do you currently hold the copyright in any works? Do you have the sole right over any type of work to reproduce, produce, publish it? What do you think? I see some shrugging shoulders. Yeah, it's not obvious, but absolutely. I didn't really go into it on the last slide, but the threshold for originality is very low. So even a scribble on a napkin could be a piece of artwork that is subject to copyright protection. The emails you write, perhaps an original text you write, Twitter, like tweets on Twitter, all these things could reach that very low threshold of originality and thus be protected by copyright. Now, that copyright doesn't last forever. It expires 50 years after the year of the creator's death. So that means that there are no longer copyright protection on that tweet, the book I wrote, the email you sent 50 years after the year of death of the creator. The law also says that you can transfer the rights in the works that you hold the ownership over. And in our situation, in our scenario, we're usually talking about transferring rights to publishers to publish a work. And that's where engineering students usually have questions about their thesis. Let's just go forward here. So I want to make sure that you understand your rights, both as a creator and a user of copyright protected works. That's really what this session is about here today. So as a graduate student, I hope that you will leave here understanding that you are a copyright holder and that you hold the rights in everything you produce as part of your program in most cases. So in your coursework, you would normally be the copyright holder of your assignments, etc. So in many cases, graduate students own the entirety of their thesis. There are exceptions to this, like if some of the work was produced under the terms of a contract, so an employment contract, if part of your RA work is going into your thesis, that's a special consideration. If you signed away your rights to a publisher and you're including that published article in your thesis, that's a consideration. And we have tools to help you navigate that. But right now, it's enough to know that FGSR is going to expect you to share your thesis on the open web. That is typical, that is the standard practice across all higher institutions of good repute. And it helps you with your career to make sure your work is out there for purposes of impact and visibility. So FGSR will ask you to sign a non-exclusive license. This does not change the ownership of your thesis in any way. It simply gives the university permission to share your thesis on the open web. So because your thesis is out there, especially because it's out there on the open web, you need to be mindful about your rights when you're sharing other people's stuff, if you will. Because while you do have the right to share things in very specific, limited ways, as I said, chances are you're going to be sharing much more than that if it's a full image or graph or chart, which is usually the case with engineering students. And we'll talk about how you can manage your rights in that area. There are also some things that you don't need to worry about, like very short quotes. So if you're just sharing 1 or 2 lines from a very long article in your thesis and you're providing, good attribution, as of course you would, saying who wrote it, where you got it from, that kind of thing, you generally don't have to worry about that from a copyright perspective because that's an insubstantial use. Also, as we mentioned earlier, if something's in the public domain, you don't need to worry about it because copyright would have expired. Public domain is a very specific legal phrase that refers to something that no longer is protected by copyright. The vast majority of what is out there publicly on the web is not in the public domain from a copyright understanding. So I just want to make that clear. And also, you can freely use works where the rights holder has told you it's okay to freely use those works. And that's, in our scenario, in our environment, that's usually indicated by a Creative Commons license. We're going to look at what all these are in a little bit more detail. Don't worry, I just wanted, this is sort of what I hope to have accomplished with you by the end of the session. Okay, so most of the engineering students I've worked with in the past 10 years or so find this page very helpful. This is on the Copyright Office website. It actually goes into everything, just about everything you need to know. It's not that long of a page. I've just given you the first bits. These slides are available to everyone. You should have got a link. If you haven't, you will within the next day or so. It just sets up sort of what I've already said and gives what we're trying to do here is give engineering students, all graduate students really, the information or the steps they need to go through to make sure that they're, or to help as much as possible prevent them from getting into any kind of copyright infringement scenarios. So the first thing you want to always do is determine who holds the copyright to the content in your thesis. As I've said, in many cases, you hold it completely because you wrote everything in your thesis. That's it. You don't have to worry about it. But that's rarely the case with engineering, rarely. Usually you've included a paper from a published article or a table or a chart from another article. You don't hold the rights in those. So the next question is 2 here. Identify acceptable uses of the content for which you do not hold the rights. And we'll talk about that in a minute, a bit more. And then if you still have outstanding items that you're wondering about, you would seek permission to include the content in your thesis. Now, with major academic publishers, that's usually a really quick and easy automated process. And that's usually the case for engineering. All right, so I've talked about published articles a few times. I know there are a lot of paper-based theses in engineering. And what I've got on the screen here in front of me are very small segments of a 4-page agreement that Elsevier uses as a sample. Elsevier is one of the major publishers in your field, and this is their sample agreement. Not all grad students are the primary authors on your paper, so you may have never seen something like this. Perhaps your supervisor or your co-author has. I want you to understand the structure of these legal documents because they deal with your rights. So first off, there's usually a section at the beginning of all publication agreements, not just Elsevier's, that asks you to fill it in and accept everything. Okay, this is a legal document that their legal staff have prepared, and it'd be really great if you just accept everything they're giving to you. That's their ideal, obviously. But I want to tell you that you should always be able to ask questions and perhaps even suggest changes in language if you need them. And the Copyright Office can help you navigate that if you feel that's necessary, recognizing that many graduate students never even see these documents. So that's typical. Another thing that is very typical is a section about granting of rights or assigning of rights. I'm not going to read through this very lengthy paragraph, but suffice it to say that this paragraph basically takes all the rights we talked about in that act, in the Copyright Act, that you have and transfers them to the publisher. So once you sign this agreement, you no longer have the rights that the Copyright Act gave you as an author. You've transferred them. Now, that might sound a little extreme, and I mean, it is. They don't really need that to publish your work. All they need is your permission. But it's sort of tempered by the fact that most major publishers will include an author rights section as well, or a section that makes it very clear what the author can do with the work. And over the years, that has improved and become more beneficial to academic authors in particular. So that's a good thing. But you still need to understand exactly what it is you're allowed to do under the terms of the contract, because it is a legal document that you were bound to once you sign it. And I understand that it may not be you physically signing it. It may be your the lead author or your supervisor signing it, but you're still subject to the terms. And it's completely reasonable for you to ask for a copy after the fact. Okay, so happily, the Elsevier agreement says that author rights for scholarly purposes including the final published journal article in a thesis or dissertation. So that's right there in the contract. So that's it, you're done. You might be wondering why I've spent so much time on this if I could have just said it's usually in the contract. There are a couple of reasons. One is that this is not this was not as typical 10 years ago as it is now. There's been a lot of change in the publishing industry in the last 10 years especially. And we had a lot of questions from students across campus about whether or not they could include their published articles in their theses. Truth of the matter is, each publisher does handle this a little bit differently. So we have a document that we created that you can look at if you're wondering. And Elsevier just happens to be the first one on this list. This is actually quite a long web page with 5 or 6 major academic publishers. And we're basically answering the questions on this page that many graduate students had about their published papers. Does the publisher allow you to put it in your thesis? That's on the left column. And does the publisher accept manuscripts that you already made available in your thesis? So kind of after you graduated. So we've provided that information for many publishers, and so that's something that you need to be aware of that's available to you. The other thing that I want to make sure you understand is that your own agreement will take precedence over any of the policies or the sample agreement I gave you. So what your co-author or you signed is that those are the terms that you are subject to. Yeah, and I'm spending a lot of time on this because that change in the publishing industry means that perhaps your supervisor is not aware of this. Some supervisors are very well abreast of the changes in publishing, some are not. And we still get students who are concerned because their supervisor's nervous about them including an article in their thesis. So just wanted to know that we have resources to help you navigate that conversation with your supervisor if needed. Okay, any questions about published articles before I move forward? Just going to give people online a chance. Okay, I'm going to speed things up now a bit because that published article question is the one we get the most from engineering students, to be honest. So let's say now that you're including a table or a graph or an image from another article in your thesis, you don't own it and you want to know if you can use it. There are basically 4 ways you can legally put other people's stuff into your thesis. The legal term for other people's stuff is third-party content, okay? So there are 4 ways. The first is just use content that's no longer protected by copyright for whatever reason. That's one. It's not common in engineering, I gotta say. This is more typical in humanities and social sciences where you're dealing with very old materials, but it's not unheard of. The next 2, B and C, refer to cases where the owner has made it clear you have permission to use it. In the first case, in B, the owner has made that clear in advance. They've pre-authorized your use of it by assigning an open license, a license that makes it clear that you can do what you need to do with it. C refers to asking permission directly from the rights holders. And happily, major academic publishers have made that very easy for you, and normally it's free. Finally, we do have exceptions in the Copyright Act that may apply to your scenario. It would be up to you to navigate those and understand whether or not you have the right to lean on that. And it is rare in engineering that we run into this, but not unheard of. And the Copyright Office, again, can help you navigate what that means in practice if needed. Okay, so those are the 4 scenarios. I'm going to whip through really quickly some examples. The first one is content that's not protected by copyright. So either it's very old, term is expired, or the rights holder has waived their rights completely. That happens, but again, it's rare in engineering. Much more common in engineering literature is where you see a Creative Commons license on an article or an image. And I'm going to actually walk through some examples of what that looks like or what the different scenarios look like. Clearly, this is not from engineering, right? This example, but it's a real world example I received a question about. What do you know about the Mona Lisa, about this picture? That's related to copyright. We've been talking about copyright terms and whatnot. It's pretty old. Like the term would have expired a long time ago. The creator passed away a very long time ago. But that doesn't mean that the photographer's work might be original. So the jury's kind of out depending on jurisdiction and the actual lawsuit that's being considered. But we just assume that there are rights in the digital image that are separate from the painting if you see it online. It's a good assumption to make. It's a safe assumption to make. There's a whole theoretical argument behind this that we could dive into, but we don't have time for that. In practice, if you see an image like this and you want to use it in your thesis, pay careful attention to any licenses that are assigned to it. This is something called Pixabay. It's a service called Pixabay. They make it clear that you can definitely use this image however you want in terms of reproduction, but you don't even have to provide attribution. Now, I recommend against that, because if you include something in your thesis and do not attribute it, the reader could assume that you created it. And then there may be a misunderstanding and a plagiarism accusation could result. So always provide attribution. It's just a good academic practice, even if the license says you don't have to. So it's not really a copyright thing, it's just good academic practice. So the next image is found on Flickr. And you can see the rights holder has said that some rights do apply here in very tiny letters. And this is our Creative Commons license. So all it says is CC, and then there's a little picture of what looks like a human here. That in our copyright world is something we refer to as CC BY, where BY refers to attribution. So Creative Commons is the institute that manages these licenses, and BY means that you should be providing attribution if you reuse it. So you want to give credit to the creator, provide a link to the original chart or graph or whatever it is, and then say if you made changes to it. That's all they care about. Otherwise, they pre-authorized you to use this image or chart or whatever in your thesis, which is great, because it says you're free to share and adapt as you see fit, as long as you provide attribution. So that's fantastic. You don't have to worry about it. You just have to make it clear in your thesis. The third image is provided by a service from the Getty organization, and they made it clear they expect people to pay for reuse of these images. So as a grad student, this would be a bit of a red flag for me. I would not put this image in my thesis unless I was willing to pay for it, because there are services that scan the web to see if their content is being used. And if you got flagged and you hadn't paid, you'd have to explain why you felt justified to do that. And that's a path that most grad students don't want to go down. So those are three scenarios we run into often. Again, Creative Commons licenses are something to watch out for, because if you're not changing the table or the graph or whatever it is you're using, any of these licenses, which is the extent of all the CC licenses at the bottom here, any of them will support you reusing that work in your thesis. Now, there's a lot of little symbols on these buttons, they're called, that refer to different elements of the licenses. I'm not going to get into that in detail unless you want to. Please ask me in the Q&A. But suffice it to say that if you're not changing the image or the graph or the chart, all the CC licenses support the use in a thesis here at U of A. There are lots of ways to find CC licenses, and there are lots of licenses that are not that open. Just very quickly, if you're accessing databases through the library website, the library is paid to give you the right to access those. Those are not free on the open web, and they usually come with a lot of tiny letters that are small print and language that tells us how to use it. So just a rule of thumb, if it's in a database, it's not meant to be shared on the open web, a library license database. Okay, and so that's all I had to say about authorized uses in terms of the rights holder giving you permission, either from the pre-authorized, the CC licenses. But there are cases where you need to seek permission because they haven't made that clear. So the first step is to identify the rights holder. With major academic publishers, this is usually really obvious and fast, that first step. The second is to ask for permission. In most cases, they make that simple. They want you to use that material, right? And then thirdly, retain documentation. So this is what you need to do in most cases if it's a journal article with a graph you're using and they don't have a CC license. Happily, many do have a CC license, so always watch for that. Just a heads up. Let's pretend that this image on the right is the one you want to use from an article. I know it doesn't look very engineering, but it's the same publisher and this is the same setup. If you see the CC license there, that's fantastic. Make sure you understand the terms. Again, if you're not changing it, it's really good to go as long as you provide attribution. If you don't see that or the terms don't apply, then you're looking for a link that will relate to getting rights and permissions or get permission, something like that. The language varies by publisher, but most major publishers now use something called the Rights Link service from the Copyright Clearance Center. So as soon as you click from the journal webpage where it says get rights, you'll see a screen like this. It's pretty much common sense from this point. You would fill in, your reuse thesis. I want to use a figure, only one, electronic. I'm not the author. I'm not going to translate it. And most will say, fine, there's no charge, no problem. You click the continue button. If you may have to set up an account, it's automatic, it takes a minute. And then you get a contract. You get an agreement that gives you a license to use that work in your thesis. Most of them are a page, maybe 2 pages. Please read it because some of them, not all, some of them have onerous terms that are not reasonable. Like they expect you to renew this every single year. Your thesis is going to be on the open web through the U of A library, hopefully for 500 years. So when you're gone, your work is there showing how brilliant you were and people can still access it. That annual renewal is not reasonable, okay? If that's the case, and it doesn't happen very often, but if that's the case, we do have a sample permission letter you can use to seek permission. It's on the Copyright Office website. And it basically provides you with language that you copy and paste into an email and fill in the relevant bits, like what you want to use, who you are. You send it to the rights holder. They send you an email back. My understanding is that's all your committee wants, is just proof that you have permission. It takes a little longer if you have to use the template. It is rare, but just know that if you get kind of conditions that you're not comfortable with from that previous process, this process through RightsLink, you have options, okay? It's rare. We're dealing with the exceptions here, which is why you have access to these slides for later. And it's on that webpage I pointed to at the beginning. Sometimes they'll say no. Sometimes they'll just say nope, or you have to pay. And I'm actually dealing with that with the Nonprofit Association in Engineering right now. And I think it's just a mistake on their part, so we'll navigate that. But if this is the case, there are things you can do. We recommend that you find something else. Like maybe there's another image that does the same amount of work for you and will express the same idea or concept in your thesis as the one you were trying to use. That's easiest. Or you include the graph or the chart or whatever, and then submit it to your committee. They review it all intact, but before you upload it to the institutional repository, you would take that image out and you would replace it with language that says, this is replaced, this has been removed for copyright reasons. Here's what it looked like. That's not ideal. I got to be honest. That assumes that the user, the reader, 100 years from now, 10 years from now, 5 years from now, will be able to find that image or whatever it is you had to remove. We don't know that they'll be able to do that. So I as a librarian, I'd really hope that this won't be the scenario, but sometimes it is, unfortunately. Okay, so what I've just described usually covers 90% of inquiries from graduate students in engineering. Are there any questions before I move forward further? Nope, okay. So we were talking about third-party content and the 4 ways that you can use other people's stuff One, that it's not protected by copyright at all. Two, you get permission somehow, either pre-authorized or explicit from the rights holder. The fourth one was about your rights under the Copyright Act as a user. So what we call statutory exceptions to infringement. Fair dealing is the one that gets the most sort of talk in academic environments, but it's not the only one that might apply to you. There's something called non-commercial user-generated content, which is section 29.21 of the Act that you may be able to lean on, but fair dealing is really the biggie. And if you're curious about what 29.21 is, I can talk about it, or you can go to the Act yourself and look. This is the law of your country. You can, learn about it for sure. But fair dealing is very brief in the Act itself. It just says fair dealing for the purpose of research, private study, education, parody, or satire does not infringe copyright. That's all it says. So you're sort of on your own to know what the heck is fair, right? We do have case law that offers us factors to consider when we're looking at whether or not your use was fair. And that would include things like, how much of the work did you use? How broadly did you share it? What is the effect of your use on that original work? Are you preventing them from making money is one question that often comes up. And once you've worked through that fair dealing assessment, you decide for yourself, is what I'm doing fair? And will I be able to explain that to the rights holder if they have questions? As I said, this is very rare in engineering, but not unheard of. If you find yourself in this situation that fair dealing may be something that applies to your work, don't hesitate to reach out to the Copyright Office and we'll walk you through what those factors are in more detail as they apply to your specific scenario. Okay. So that's all I had in terms of the copyright section of this presentation. I did want to give you some tips for talking with faculty, though. These are things that have come up over the years. Often grad students are working as research assistants or in other capacities in an employment scenario. And the default in the Act is that anything you produce will be owned by your employer. So that can cause some confusion for some grad students. So it's a good idea to just ask whoever's hired you whether or not you have the right to use a jointly produced project in your thesis. I can't give you the answer because it will depend on the terms of your specific employment contract and your supervisor. And a heads up, sometimes your supervisors never had to think about this before. So, so keep that in mind. Many have, though. Number two, always get a copy of that legal contract when it comes to your publishing. Always, just for your own sake, like 50 years down the road, 20 years down the road, you want to know what was agreed to, and get that copy now. It's completely reasonable to ask your supervisor, your co-author, for a copy of any co-authored any publishing agreements for co-authored articles. And finally, this speaks back to the changing nature of the publishing industry. Question the need to embargo your thesis on copyright grounds. There are a lot of people that haven't had to interact with the publishing industry very much in the last 10 years, and they still think you need to embargo for copyright purposes because the publisher doesn't want to share the article in your thesis. And that's so rare now. That's a very rare scenario. So if you find yourself in that conversation, feel free to tell them I said it doesn't happen very often anymore. and we can find the documentation to determine if your publisher supports it or not. Most of them do. There are still a few that might question the practice, but I haven't seen one in years. So those are some tips for communicating with faculty members. I have a summary here, which, to be honest, I wasn't going to spend a lot of time on. It's here for you to review after the fact. Just kind of covers what we've talked about in the last half hour. If you're working as a teaching assistant, I didn't include any specific information. I wasn't sure about the level of TA-ship activity in this course, or this group, but I'd just like to point out that FGSR does have a copyright in the classroom workshop that is completely self-directed online, which will walk you through everything you need to know as a TA. I'm also happy to answer questions today, or you can just email the Copyright Office at copyright@ualberta.ca. Generally speaking, if your questions about TA work, anything to do in the classroom, copyright@ualberta.ca is the best email address to use. FGSR also has a couple of now mandatory sessions, academic citizenship requirement, they're calling it, that include copyright modules. So I'm just noting that here as well. And resources on copyright for future reference. We have some great instructional modules that we've created here at the University of Alberta related to copyright. Just FYI, in case this lecture has piqued your interest in this area of law, we've got a lot of resources on academic publishing. And that's it for the formal presentation. If you have any questions about copyright, I'm happy to field them now.
Okay, thank you very much. We are giving some time for people in Zoom. If they have any kind of question, please write it down in the chat and we can ask here for you.
Yeah, we'll give people a minute or two. Yeah.
I'm just wondering, in the 50 years between the owner's death and when it expires, who owns the rights?
Great question. The estate would normally, unless they've bequeathed it, unless there's something specific in the will, they would normally, we would assume it was the estate that took over the rights. And it's interesting to think about that period of time, because the purpose of copyright law, if you look at the preamble to I think it's this current act, if you look at the legislator's intent, the purpose of the Copyright Act is supposed to be to incentivize the creation of new work. So the idea is, if you give people the sole right over their work, it'll incentivize the creation of more work. So that 50 years past the year of death makes that a tough sell. And in Canada, we'll actually be extending that to 70 years. We were waiting for an exact date. The legislation has passed to change this, but we need to know when it actually comes into force. And that's to be in line with US legislation. So that was negotiated as part of a trade agreement, the CUSMA, Canadian-US Mexico trade agreement. So we had what some would argue is a cultural policy that was negotiated as part of a trade agreement and is preventing hypothetically millions of works from entering the public domain in Canada for an extra 20 years. Because remember, copyright is immediate. So everything is protected by copyright that meets that originality threshold and is in a fixed format. So from a library's perspective, that complicates our digitization practices, because we're digitizing older material. And if it's not yet out of copyright, we need to have the resources to track down the owner, to ask permission. And we just simply can't do that at scale. So it complicates things in the library sector considerably. Yeah. Thank you for the question. There's also no data to show that it actually incentivizes economic activity.
Questions from people?
Okay. Great, thank you.
Okay, thank you very much. Thank you to the people in our the participants and the people here. Thank you, Amanda, for the talk today. Very useful. And see you next Wednesday. Thank you.